working. Let's give it a minute. Oh, it says I don't have permission.
Oh, goodness. All right, we ran into this before. Let me just record it and we'll figure it out later.
Yeah, okay.
All right, we're good to go, Jay.
All right, great. Thanks, Brian. Welcome, everybody, especially to all our guests. We appreciate your time and being here. We need to start with the ethics statement. The Ethics Commission says we have to avoid any conflicts of interest or the appearance of conflicts of interest. So if anyone has a conflict or knows of a conflict or the appearance of a conflict, please let that be known to us now and refrain from taking any action, voting on any matters in which you may have a conflict or an appearance of conflict. Anybody know of any conflicts? All right, I don't see anybody raising their hand or speaking up, so I think we're good. Welcome, everybody. I think, is it okay, Nicole, if we start and let you kind of fill us in, especially our guests, from where we are at this point, and then we can open
Yes.
the floor for
So
comment?
sure. So we received this inquiry from Bert Kemp asking for the Ethics Committee to look at creating an exception for lawyers in public defender's office. His initial request was a request to treat as separate law firms when a public defender in a multi-county district has separate offices in each county, all under the supervision of the one public defender, but to treat each county's office as a separate law firm and to deal with the conflicts of interest issue. So when the public defender is asked to represent either co-defendants who are adverse to each other or a defendant and a witness who is adverse, or maybe the defendant is adverse to a former client in which the office has confidential information. So we prepared a proposed ethics opinion to try to resolve those conflicts of interest. And the proposed opinion was based on Rule 1.10 of imputation of conflicts of interest. And so not applying the Rule 1.11, which deals with conflicts with government lawyers, but instead Rule 1.10, which is traditionally applied to private law firm lawyers. And the opinion said that each office that operates separately has distinct leadership, staff, and physical space, that they put screening measures in place, and that any lawyer who was actually conflicted would not be involved in the representation. So when the subcommittee met to discuss that proposed opinion, the general spirit of that conversation was that an ethics opinion was not the appropriate way to deal with conflicts. We had Jacob Ward and Seth Johnson, who participated in that first subcommittee meeting, and they expressed their concern about the appearance of impropriety, of the public thinking that one office is going to represent co-defendants who are adverse to each other, or a witness in a code of basically just a conflict of interest. And so they raised several concerns about that. So at our next subcommittee meeting, we discussed the Wisconsin rule and what Wisconsin did to eliminate public defenders from the definition of government lawyers and applied Rule 1.10. And so I gave you all the draft, or not the draft, but the rule that Wisconsin did. We had another subcommittee meeting. We talked about that. Bert actually joined our next meeting. I believe that was the next meeting that Bert joined. And he is the inquiring lawyer. And Bert expressed that while he understands that we can't or we might not issue an opinion or a rule that says that we're going to treat each county public defender office as a separate office. However, he did ask us to look at what do we do or create an exception when the public defender's office has a conflict, but no lawyer in the office remembers the prior client's case. So we're talking about a former client who is now the victim in a case where the public defender represented the defendant, but because of that prior representation, the public defender's office would have confidential information about the victim. So that was just one example. And so you all discussed, or Bert was asking for an exception for the conflict to be waived without asking the victim, former client, to sign a waiver because no lawyer in the office remembers that case, or the lawyer who did handle that victim's case, former client, is no longer with the public defender's office. Um, and I think there was one other issue that I might be forgetting. But so the subcommittee discussed all of those kinds of issues, and that was the first time that they had discussed Bert's more recent concerns that were not part of the original inquiry. And so the subcommittee discussed all of that. And then we ended the discussion with looking at the fact that indigent defendants in criminal matters have a constitutional right to representation. And maybe we could come up with a rule that would allow an exception for the public defender so that they can overcome the conflict by screening, for example. So Brian did a great job and came up with a draft of a proposed change to our Rule 1.10. And you have that in your materials, but it says that the disqualification prescribed by paragraphs A and B, so we're in Rule 1.10 that says when one lawyer in the firm practicing alone can't represent a client because of a conflict, then all of the lawyers in the firm have a conflict. So imputation of conflicts. When applied to members of a public defender's office or the North Carolina Department of Justice, may be resolved by following the screening and notice requirements as set out in C1 and C2. So C1 and C2 of Rule 1.10 says that when a lawyer becomes associated with the firm, no lawyer in the firm can represent a client if the lawyer is disqualified by Rule 1.9, unless the personally disqualified lawyer is screened from the representation and written notice is promptly given to the former client of the screen. And so the comment that Brian also drafted for our proposed Rule 1.10 explains that lawyers working in public defender's office have, a constitution, have a right, have the duty to represent people who have a constitutional right to counsel. It also talks about the Department of Justice and the fact that they represent government entities. It goes on to say that we have to apply our rules reasonably and to address this special circumstance with public defenders and attorney general's office where they are charged with representing people who have a constitutional right to that representation. I also sent you yesterday, I'm losing sight of my days. Um, South Carolina, just to show you that another state is doing what we are thinking about doing. So South Carolina's Rule 1.10 on imputation of conflicts also has a carve out for lawyers in public defenders' offices and allows them to screen so that there isn't an elimination of representation, especially in circumstances when there are not enough lawyers on a court-appointed list, which is the same thing that we're trying to address, that if the public defender's office has a conflict and can't represent a client, they have to refer it out. But in many North Carolina counties, there are legal deserts. There aren't enough lawyers to refer these conflict cases out to. So that is where we are.
That's a very good summary. Thank you. Jacob and Seth, I'll start with y'all. I don't want to put you on the spot, but if you have any comment, I mean, I think the short story there is since y'all were on the subcommittee meeting, and I think the subcommittee kind of had one thought from your comments and our collective comments, and then once we came to the next subcommittee, it changed some, and there were new ideas and new thoughts brought to it. So I'll open the floor if either one of y'all have any comments as to where we are now. Seth, do you want to say anything about that?
Yeah, I'll just say the first thing that jumps out, not to try to be problematic, but the written notice requirement. Um, when we first opened our office and started taking clients, we attempted to send out written notice to our clients as far as court dates, notices of appointment, and that thing, things of that nature. And about 75% of what we sent out was returned. So that's not going to be any better with victims. I don't know, maybe, but I mean that's a problem. The written notice, and then if so, the way I see that playing out is if we get to a contested matter and we knew that the victim of a crime was a prior client, then we're going to hand them written notice right before the trial starts. How's that going to play out? Because you're giving somebody at that point an opportunity to avoid a tense situation unless they really want the case prosecuted. And those are just thoughts, not meant to be problems, but stuff that I've seen.
I'm sorry, Seth, what county are you in?
Iredell and Alexander.
Oh, my home counties. Okay, I'm from Catawba originally.
Okay, yes, ma'am.
But okay, great. Question for you though. Do y'all have an issue where you represented people before and then, I mean, maybe you represented a victim before or even a co-defendant in a situation and now you're in the place where you're like, okay, we don't have enough attorneys to refer people out, or do you have enough attorneys that you can do that? Like, what does your list look like?
Our lists are pretty strong right now, and we're compiling. A lot of the lawyers that came to work for my office were local lawyers, so they brought their conflicts into the office, and that's a lot of the sorting out that we've done since we've started.
So I think my question would be for those folks that are in these more rural counties that don't have attorneys, because at least y'all get the ones from Charlotte. You know what I mean? You kind of have Mecklenburg, you kind of have those other larger counties, but the ones that are further out, like further out east, where they're in these legal deserts, legal oases, those kind of things, what would you suggest for them? Because I think the issue is that they don't have any attorneys they don't have, a plethora of attorneys to refer cases out to.
And I think Jacob could speak to that.
I can. I'm sitting in a legal desert right now. I'm in Bladen County, our Bladen office, and there's one person that does A&D work other than my office. There are no people on the court-appointed list that do A through D work. I have to call and beg people to do them. The proposed amendment, I appreciate it. I think it would be exceptionally helpful to districts like me. It is obviously not brand new because South Carolina is doing it. I know that we have to send notice. We will do our best to send notice. We will get notice out. But reading the rule, it doesn't look like the prior client can block us as long as we provide notice and that we are following the ethics rules of screening. So I'm in favor of it, particularly because I am strapped in Bladen. I am strapped in Columbus. Brunswick, I'm okay because I can pull from New Hanover. But some of these districts are in real disarray because there's nobody on the PAC list. I know that Jana out in Cherokee, she can't even hire attorneys for her office. She's struggling there and has very limited PAC. And we got to do something because people have to have representation. Indigent people deserve good representation. And I'll be honest, they get fantastic representation from my office. So I am for it. I think it is needed. Something has to change. And I think this is a change for the better.
So Jacob, I'm, in Wake County, and my big issue is I only have 7 parents on my abuse, neglect, and dependency, and our public defender's office doesn't have parent attorneys, excuse me, and our public defender's office doesn't have assigned ones. So even I can relate as far as that piece. And to your point, I guess I just want to say this, and I'll be quiet. I think at the end of the day, y'all, I just don't want us to strap ourselves down because we live in counties that have these and not and strap down everybody else across the state who is struggling. Because at the end of the day, people deserve representation. They deserve, to your point, good representation. And because we are somewhere where it doesn't hurt us, I just don't want to hurt other people. And the last thing I'll say about it too is, just being mindful that even sending notice, I mean, as long as you mailed it to the last known address and can show that you did that, doesn't require that it actually be physically with that person. I mean, it's up to them to share their address, change their addresses, those kind of things. I mean, as long as it's mailed out and you've given them the proper notice and can show that you mailed this to the last address or the record that was, or the address that was on the record, I mean, I think that would suffice in my mind. But thank y'all.
Eddie, go ahead. See your hand.
Well, Tom was first, so I'll let Tom, and then I'll jump in after Tom.
Oh,
No,
sorry.
go ahead, Eddie. Go ahead. We've been on committees before. Go ahead, man.
No, I guess one, I'm not really a fan of. It seems like it's watering down conflict standards because of the inability to find lawyers to handle these cases, and I understand that. But I think I'm sort of that causes me a pause in terms of watering down the conflict standards and what that means for uh, the clients that we represent, and clients that we represent currently and we represented in the past. Um, but mostly, I'm sort of puzzled by this idea that if a lawyer is no longer in your office, then you can just move forward, because in my office we discuss a lot of cases. We handle a lot of cases together. It may not be your case, but you may have covered that case, and so you may have intimate details because you covered that case. You may have brainstormed that case with your colleague to talk about what we're going to do for trial, what we're going to do, try to get the best plea offer possible. There's a lot of collaboration that we do in my office, and so just because a lawyer leaves the office and he left 3 years ago and uh, he's no longer with us, then we can just you know cross-examine the witness on something that we have intimate knowledge on. I'm not sure how that's going to work in reality.
Eddie, what county are you in?
I'm in Mecklenburg.
Okay, so what about these other counties, such as, I'm sorry, the gentleman I just spoke to, where he has multiple counties with different offices where they're not collaborating? I mean, I understand Mecklenburg's a lot like Wake, so you all are very tight knit. But what about these counties that have separate public defenders offices that, are in different counties where they're not talking? What would your suggestion be for that? Because they're not having those discussions.
You mean, but not internal discussions in terms of
Well, you're
hey,
saying that, yeah, you guys are saying that y'all collaborate, and I get that. You know what I'm saying? Like you talk about cases, et cetera, and so forth. But I'm talking about in those counties where they have 5 or 6 counties, the public defender is one public defender, but they have multiple counties, and these public defenders work in separate counties that may not be speaking to each other, right? Because they are in separate counties. They may have two in one county, two in another county, two in another county. Maybe those two are talking, but not somebody else. Then where would that conflict be in those type of situations? Because I think that's what we have to be looking at, is not just where we are, but where other people are. And if they're able to, you see what I'm saying?
no, I understand. But I think we probably should be looking at the whole, because even if it's better somewhere else, it still impacts you know Guilford and Mecklenburg and Wake, and so and same thing that what happens here may impact elsewhere. So I think we have to look at it as a whole, and so that's where I come from in terms of my office, in terms of other offices that I'm aware of. It seems like in public defense we want to be collaborative. We want to work with each other. You may be out, somebody cover your case that day, and now 2 years later you're cross-examining that witness that you cover, even though you weren't the attorney assigned to that case.
But what would stop you from being able to still say that this is a conflict I don't feel comfortable doing? Like what stops you from that?
Nothing would. So, if we go forward with this rule and we make tweaks to it or whatever, it is a permission for the lawyers to deal with the conflict in this way. So if you're in Mecklenburg, or in these larger counties, Wake County, where you have lawyers on the appointed list and you refer it out, you can refer it out. So the rule is not going to require you to keep the cases in hand, in-house. But if you want to keep the cases in-house, then the rule says you can, well, the proposed rule will say you can screen and give written notice.
So Nicole, to be clear, the situation that Eddie's talking about, he would be able to say, no, I'm not moving forward with this case. It still gives him that ability to do that.
Absolutely.
But it also doesn't tie the hands of somebody else who may need this rule to assist them.
Correct.
And if I can jump in here and say, add that to Eddie's scenario, the lawyer that was collaborating with someone, the lawyer that I guess we're talking about the main lawyer that was representing the defendant has left the office, but there were his former collaborators or her former collaborators that are left behind. They had a lot of information. Those folks could be screened. I think that's what this proposed rule would really require those folks, because they do present the conflict under 1.10b. But with this amendment, it would allow those collaborators to be screened off and allow the public defender's office to still provide the constitutional representation that defendant is guaranteed. And I know, Eddie, I know you're like, yeah, how realistic is that? And I
Yes,
get
that's the thing.
I get it. And I think that's the thing that, where so much of the rules to me, it's the frustrating switch that I've had when I was in the disciplinary department where it's just kind of, does it fit in the box? And if it does, then you've got a rule violation and we need to go forward with some sort of discipline. This one is one of those where it's going to rely upon the good judgment of the lawyers that, like, if we're talking about a collaborator that worked with a former colleague 10 years ago on a case, and they're like, man, there's a lot of stuff here. I remember talking about this one with them. I feel like I need to screen myself off because I present a conflict, but this person doesn't have anywhere else to go. They need the public defender's office, so I'm going to have to get screened off completely. And that's one of those things that we have, the screening rules that we have in place in 1.10 rely upon lawyers acting in good faith. It's presuming that lawyers who get screened remain screened and actually respect the screen. And so I think it'd be a similar thing here. Now, if you have a collaborating situation, you're talking about like 5 or 6 attorneys, all were in that room, then it might not be really practical to screen everyone off. Now there's only one person left and no one else can collaborate with that person. If this is a big charge, we're talking about, some big time felony charges, you're going to need more attorneys. Maybe the public defender's office can't actually take on that case and we need to find an alternative path. But I think that's where it's really going to come down to a case by case sort of evaluation of how many people are we talking about that would realistically need to be screened off, because any one of them that retains that information would need or presents a conflict. And under this rule, they would be allowed to be screened off. And you would then ask the question of, can the public defender's office still provide competent, adequate representation? And I guess that would be kind of, you have to kind of look at the ripple effect of this amendment there. But it might not be realistic, and I get it. That'd be a tough thing.
Brian, can I follow up on some of that?
Yeah.
I mean, I was reading your proposed section F, and I guess, and I'm just trying to make sure I understand. When I read the South Carolina one, it's almost like there's a presumption of no conflict unless you can really somehow document that some confidential information is at stake here that would somehow prohibit a public defender from representing that person. Whereas the framework under our rule, it's almost like there's a presumption of a conflict, and the only way you overcome that presumption is by, by giving notice, screening, if applicable, and then giving notice of that former conflict or the former client, regarding that potential conflict. And I'm just sitting here thinking from a practical perspective, if all it takes is a written notice to the last known address, that's what we're talking about here. That's fine, because probably 85%, I would guess, in my rural area, probably at least 60% of those individuals that the public defender's office has represented in the past that may now have a conflict with a current represented client, right? They're not living at the same place. So it's almost like, are we really doing anything by requiring to send that notice, or are we just, for lack of a better phrase, is it a CYA action that we are taking in order to, out of an abundance of caution, give that person the notice of the potential conflict under
Yeah.
the circumstance? I mean, I almost like the presumption, or the South Carolina rule, like there's a presumption that this public defender's office is going to represent this person unless there's some, in some sense of the word, provable tainting of the confidentiality in cross chatter or cross representation or those individuals within that public defender's office.
Right. That's no
You know,
time. I hear exactly what you're saying. I think it's kind of both. And one thing that I think would be helpful, or it's helpful for me when I'm answering ethics calls on this topic, is that the person that's receiving the notice is receiving the notice. They are presenting there's some sort of involvement with this former client, um, and their involvement in the current charges, like in this scenario, right? The conflict they're presenting is because they have some sort of role in the current charges. Typically, they're the victim, or they're going to be a witness that's going to need to be called. In that scenario, I guess I'm typically acting on a presumption that if this person is presenting a conflict because of their involvement in these charges, then somebody can reach them. They're around. Now, I'm not saying that they're at the same address where they were before, or that even if you get from the district attorney, say, hey, I understand that you're the victim in this case is presenting a conflict for our office. We need to provide them notice because we're enacting screening procedures, and we need to know their address. So can you give that to us? And we kind of all have to work together here. Are they going to give us the right address? All that
right.
stuff. I don't know, but the point is, usually these folks that if there is a conflict implicated by Rule 1.10, typically we're talking about an individual who is not just kind of who knows where they are. They are involved in the charges. So that's where I feel a little more at ease with the notice, or I should say the notion of notice. It's not perfect, but I do feel like we'd be able to actually provide that notice. And I see what you're saying about the South Carolina rule. And I will confess, I was unaware of South Carolina's rule when I drafted the thing that I that I sent you all. I just kind of had creative writing space and started writing. And I'm happy to see that it's somewhat similar, but there's
Yeah.
kind of, I think the version, and I guess that's another thing. The other thing that Nicole and I sent out, this proposal, is one that I don't think Nicole and I are sitting here feeling 100%. We hope the state bar council adopts this. We want to vet this. This is a jumping point for the conversation because we were talking at that last meeting of what if we actually created some sort of exception under 1.10? What would it look like? And maybe that can start the conversation. So I guess I just want to be sure that everyone on the call is aware that if y'all want to change it, you hate it, you like it, that's all on the table, and we need to vet this. This was just kind of a starting point for the discussion, but yeah, so that's where we may be able to borrow some stuff from South Carolina, and their rule. I don't know how long that's been in place. I know Wisconsin's version, they have a little bit of an exception for public defenders that we had referenced before. I think that's been around for gosh, Nicole, am I remembering correctly, like 10 years or something like that? It's not been a long time.
Yeah, it's
Um,
been around for a while. I'm not sure about South Carolina. I asked Suzanne to do her magic, who's our research queen.
yeah.
And she came up with a rule. She found South Carolina's rule either yesterday or the day before, whenever I sent it to you.
Yeah,
That's
yeah.
okay.
So yeah, I guess all that's to say, Tom, I do think the notice there could be problems with it, given the person's involvement that creates the need for notice. I tend to think that it's more than just a CYA move. I think it actually could be meaningful, but I'm basing that on kind of a presumption there.
And I guess to follow up, then where does, and again, I'm a guy who hasn't been in private practice for over 20 years. So this is something that, frankly, is foreign to me when it comes to the conflict, the imputation and the conflict rules as a prosecutor. So, practically speaking, then, what does this look like for, obviously, if it's apparent that a lawyer has a conflict, that, oh, yeah, I can't do that case, screen it from me, get me out of the way and keep me away from it. Does that satisfy this rule if then we give notice of this other person or to that person with a who and then what flows from that is, does that person have a veto right? Does that person have the ability to come in and say, yeah, I know Tom Anglem was that public defender, and even though he's been screened off from this case and anything to do with it, does it give that person the ability then to say that public defender's office legally can't represent that defendant in this matter?
Right. I'd say no, it doesn't give them a veto right, but it gives them the opportunity to raise the concern with the court. And that was always the purpose of notice. It's supposed to be something that, hey, we are taking our steps to screen this person off, kind of the practical steps of this like under the rule as it is now, we're talking about that situation where an attorney joins a firm, they bring conflicts with them, and then suddenly, the firm has a conflict and they go, wait a second, we never actually had this conflict exist until this person came from a different firm where the conflict originated. So we're screening that person off, but we are giving notice to the impacted person. Hey, this lawyer works over here. We understand that you have a conflict with that person, but we have taken screening measures. We've notified you promptly. That allows the person to take action, step in front of the court and say, hey, I need to move to disqualify the public
Right.
defender's office, the
Right.
the
And
private
that's
firm,
how we
whatever.
handle it with private lawyers under Rule
Yep.
1.10.
Yes.
Okay. Thank you guys. I appreciate that. And with all those that have their hands up, I appreciate you indulging my follow-up questions as well. Thank you. I'll mute myself now and listen.
Well, thank you
Thanks,
for those
Tom.
questions.
Let me, Ms. Baker Harrell, you've had your hand up for a while. Let me hand you the floor and tell us what you think about this.
Thank you. I'm in a multi-county district. I'm Orange and Chatham, and I think I heard someone mention earlier, two do the two counties or the multi-counties, do they collaborate? Yes, we do. We have text threads, we have team threads where we bounce ideas off of each other. And sometimes, because we're right beside each other, clients cross county lines. And so they can be represented both, same person represented both in our Chatham office and our Orange office. I like what the proposal has set out. And part of it is because the notice requirement, but the screening process, that sounds to me what's the real key here. You screen it, you find out where the conflict lies. And to use a real scientific term here, if it feels icky, then we get out of the case and you leave it up to the attorney or the supervisor or the chief. I mean, there are countless times where people come in my office and they're telling me about something and they're looking at the time and I just look at them and go, that's icky. We need to get out of it. We don't have a lot of people on our PAC list. I won't call us a desert unless you think two people on a list is desert-like, but we're not quite zero, but we do have this problem. And I think the problem is going to continue to exist as far as our PAC list. And this proposed rule kind of resolves this. And it also requires a little trust in and belief that the attorney is going to do the right thing. Or the supervisor or the chief public defender themselves, they're going to do the right thing and recognizing this might be too close or this might, there might be a time going, it's been 10 years. I think we're safe. Oh, this was 3 months ago. We shouldn't touch this. Allow them to use their sense of discretion in determining from the screening process in determining if they should keep the case or if they should withdraw from the case. But overall, I do like what the proposal says, and that's my 2 cents. Thank you.
Thank you. I don't know who is next, but Deontay, you want to take, I see your hand too.
Thank you. And I'll just be very brief because I only have Wake County, so this is not something that we run into, but I have reached out to a couple of the other multi-county chiefs, and the opinion goes all across the board about it. Specifically, I talked to Laura Gibson, who represents District 2 on the coast and has a very large district, and she was opposed to it. And one thing that she had brought up, and it may be something similar to what Chief Harold just talked about, But with Odyssey and then putting all of their notes into Odyssey, there is no way to funnel people out of Odyssey. Obviously, I would like to trust, and Wake County does not use Odyssey in that way, so that has never been a problem for us. But, and we want to trust all of our assistant PDs, but what if they don't trust each other to have not looked in each other's files, which we have all rights to do? I was trying to keep a couple of notes, but I think Madrina just hit it. Even the multi-county districts, she had said they do talk to each other. They are very collaborative, and we keep on talking about attorneys that aren't no longer with the office. But the bigger problem is going to be legal assistants because those do tend to stay a lot longer time. And if you're running her off as well, you want your legal assistant to be there for as long as he or she possibly can. Um, and then finally, I think I would be in favor of the proposal as well, but I want, especially when hearing what Jacob has to go through and the fixes that this can make for him, I would just want it to be clear that this is supposed to be in the sound and exclusive control of the chief PD, because I think with a change, if it's just saying we allow this to happen, I have good relationship with my superior court judges, but I can also see them say, "Hey, Bar says you can do this, so you are going to do this," and we need a shield to protect us from that because yeah, and I could also see district attorneys wanting to get involved in what they believe the analysis of our conflict is and what the bar's rules are stating. So with that, I want to be exceptionally clear that this is a chief PD call and within their exclusive and sound discretion, if that is possible.
Thank you.
And
Tara,
thank you.
Yeah, I just wanted to, I really think this subcommittee has been so interesting because we started off over here and ping-ponged around a little bit, and now we're back at a different issue that I do think is we've gotten to the heart of it very quickly, and I really appreciate Brian and Nicole navigating us to get to this point. But in our initial meeting, it seems like all of our, I say all, we were all kind of on the same page. This is a terrible issue. We want to help, but treating it as three different law firms or treating these counties separate, we all kind of agreed it's a nice sentiment, but it probably doesn't work in reality, especially if you have an involved chief PD and with these new computer systems. So I appreciate those issues everybody brought up because still think those are very real. And like what I remember Fran bringing up about you want to foster these mentorship opportunities and foster these relationships between PDs. And I think that while we all agreed, okay, we can't completely Chinese wall these different counties, we still want to help. And then Bert brought up this passionate argument for maybe a slightly different issue, and y'all managed to bring all that together and come up with this amendment. And I think that what Mr. Thomas was speaking about, I think that hits the nail on the head because we want to give our PDs we want to be a protection from perhaps a judge who says, you have to take this. I'm not allowing you to withdraw. Maybe a conflict comes up later. So I think that South Carolina's rule, maybe the verbiage is a little strong because I, I mean, it says you're in it unless you can prove to me why you shouldn't be. And I think we need to carve out something for our PDs to say, this is my, analysis of it and we're out. Or say, hey, while it could be in the gray area, none of my people working on this have any memory. There's no true conflict. I think we can take it. And I appreciate the direction we're heading because I do think it allows us to give a little bit of help without taking away the protections the rules offer and protecting kind of what our PD's offices are trying to do. So Jacob and I are in the same district, so I'm going to defer to whatever he says, but I'm private appointed counsel and I like that this gives them a chance to say, hey, this is maybe something we could handle that we couldn't before. Any load we can take off of them, I think that we should. We just all agree we can't do it at the cost of the integrity of the PDs or, just from a workload perspective. But I just wanted to point out that I feel like we've kind of gone all over the place, but I'm happy where we've ended up. I don't know if we want to keep this exact wording, but I really believe we're headed in the right direction.
Thank you. Yeah, we have come a long way, and it's good conversation. Ellen, you had your hand up, and I'll come back to you, Judge. I see your hand.
Yeah, just really, I had a couple of thoughts when Tom was talking, and I think practically the South Carolina, I love what Brian and Nicole have done. So I support this. I'm not troubled by South Carolina. I don't think South Carolina's is that much different. I think the reason they've written it this way is they don't allow screening in private firms as I read their rule. So they've actually gone even further and said, we're going to screen, right, when we have this issue in this very narrow space of, legal aid, which I thought was interesting and I hadn't thought about, and I could see that coming back up. Legal aid or public defenders or others, but I'm not troubled. I'm not troubled at all by the language of South Carolina. Maybe others are, but I think they've done what we are talking about doing. I don't think it's aberrational.
Thank you. Judge Parker.
Yeah, I just want to say, in regards to the comments, and especially like, what Deontay was saying, as far as understanding that there is just, once again, this broad spectrum, of people who are in support of this and people who are not. And I think the biggest thing was, and the way we got here, Tara, to your point, is Bert was very candid with us for our guests that were not here last month or a few weeks ago. And he just said, look, at the end of the day, y'all, people need representation and we're going to give it to them. So quite frankly, we are doing this already because we don't have a choice. We don't have attorneys on the list. There's nothing we can do about it. What we don't want, though, is people being brought in on grievances for doing something and didn't have proper guidance on what it is. We have it now. It's in front of us now. He was candid because he's getting ready to retire. And he said, at the end of the day, y'all, this is a problem. So if we're not going to address it, we're still going to have to go out here and do this because at the end of the day, we're in legal deserts and we need it. Right. So whatever the language is, but we got to be honest about the fact that while this may not be happening in certain places, it is happening in other places because people need representation. And at the end of the day, like Deontay said, and I said this last meeting, is that this is why we need to put this in the discretion of the public defender, of the chief public defender, who was selected by the senior resident Superior Court judge to be able to make decisions, to do the hiring and firing of that office, and would be able to make the call on whether or not this is a conflict or not. I agree 100% wholeheartedly on that. I just think that we should not pigeonhole the entire state because of nuances of things that don't apply to us, because there's so many people who need it. And we have 100 counties that need representation as much as possible and as quickly as possible. And we don't want people saying, oh, this is your lawyer who doesn't want your case, who doesn't want to do it for $65 an hour. And it shows. Right? That denigrates the entire process of the public defender's office. People already, I'm from the bench saying public defenders are amazing. I'm a huge proponent of them. They do great work. They are excellent. You have an excellent attorney. I've got to say that from the bench, but people are rolling their eyes like, yeah, right, whatever. And if we try to put people on these cases, that aren't there all because the public defender's office has a 10-year conflict that nobody even remembers anything about, then what are we doing? Right? We have got to promote and protect the integrity of these offices. And the best way to do that is to allow those public defenders to do that within house. And I've got to go to first appearances. Love y'all. We'll continue this discussion.
Thank you, Brian. Hey,
well, I've got questions that I wanted to pose to the group just as we continue this thought process. So I want to give way to the chair of the ethics committee that has joined us today, Judge Dorothy. So you go first, Judge.
So I just wanted some clarification, and thank you for entertaining my question. I'm glad I finally got to be able to attend another meeting. So I was trying to look back really quickly at the proposed rule with the write-up that you all did. And in light of what Deontay was speaking about the chief public defender being given that authority to make the decision, does the language, and I just couldn't find it fast enough, Brian, does the language include that analysis on the front end being done completely by the chief public defender as well?
No, it doesn't. And I think that would be something that we could clarify
Okay.
and I think I could see it being in the comment
Okay.
To clarify how you go about doing this in a public defender's office, because the
Right. So
whole
that would be my
notion. Yep,
suggestion. And that's
yep,
why I was looking for that language, that it should be some language to include it somewhere to make sure it's very clear that the chief public defender should do the analysis on the front end and be given that authority completely throughout.
yeah,
So
yeah. I
that,
think the rules support that because, as the chief public defender, then you're responsible under like Rule 5.1 for all
right,
of your associates, the other folks that you supervise. So
right.
it does funnel that way naturally, but we could more explicitly point that out again, kind of to the earlier point of providing guidance, letting folks know just what you need to do, what you need to consider, all that kind of stuff, and making it clear on how you go about this process.
Yes.
Um,
Thank you for that.
so my questions to the group, there's a couple that have come up. One was kind of a practical one, referring to something that Deontay had said, and I think Eddie, I saw you nodding along, the notion of the notes that folks put in Odyssey, and those being accessible. This is just kind of a technical question that I have. Are we talking about notes that lawyers, kind of their like personal work product notes that folks are putting in Odyssey? Or are we talking about public notes that, say, the district attorney's office can see too, or that anybody who asks for kind of makes a public record request? Because I know private appointed counsel can't necessarily get that because they don't have access the same way. But if somebody came along and said, I want to see all the notes on this particular case file entered by the attorneys, would that generate what you were referring to, the public defenders that are putting their notes in?
Oh, Miguel, I'm
Well,
off mute.
I'm sorry, Deontay, you can go. I was
Oh,
going to say,
uh,
answer
yeah,
saying, I
and
don't.
you can clarify if I'm wrong, but Odyssey is used. We have however many different public defenders, people use Odyssey all those different ways. The way that Odyssey was constructed, it is supposed to be an entire discovery platform. So within Odyssey, I could put down everything related to my case, including attorney notes that could be shared specifically with the people that are in my office. So I think that was her concern, is that those would always be accessible, and there's no way to say this is accessible by everybody in the Wake County Public Defender's Office except for this person. And that is some of the nuance behind it, because not everyone uses Odyssey to that extent. But as PD's offices try to go more digital, I could see this popping up more. And Woodrina, I'll pass it to you in case you have clarification and you have a
Well,
two
can I
people
can I
office.
can I ask a quick
Yeah.
follow up on that? Are we talking about confidential information that's going in there? That's what I
I would,
was kind of getting at.
Yes.
Probably. Yeah,
yes,
probably.
Yes. Okay.
yes.
Okay.
Yes. So the way Odyssey is set up, PD's office use what is called attorney manager. And attorney manager, what we were told and when it was implemented, attorney manager is supposed to be our client's file. So everything that you would normally have on paper, you can screen and make it digital and assign it to your particular client's file in attorney manager. So yes, confidential information is going in attorney manager. And there are some PD offices that have gone completely digital, basically saying all of the information is contained within, for their clients, is contained within attorney managers. And then there are others that are just, they use it, but they also have the paper as the backup, or they primarily use paper as the backup. Every PD's office is different. I do not believe that information, because a lot of it's considered work product. I don't believe that information is subject to Freedom of Information Act requests, because it is our actual client's file and their confidential information. I hope that answered the question.
Yes, no, it did. And that's where I was kind of trying to sort out how this would be different in other scenarios. And I think it's just the ease of access. Even in the traditional 1.10 imputed conflict situation where you can screen, in theory, that lawyer that brings the conflict might have the paper file. They might have notes from 5 years ago, whatever it is, and somebody could go access that if they really wanted to. It's just a lot harder. Now it's really easy with Odyssey. So I get that. All right, the question, I guess, maybe building off of that was, does in light of the ease of access, does this bring up any sort of, I don't know, grounds for ineffective assistance of counsel, or an MAR or something like that, if we allowed this? And could a client come along later on and say, hey, I didn't actually have effective counsel because I was represented by the exact same office that previously represented the victim, and they said they screened that person who had information on me off, but I don't think that really happened. Does this create a problem for, appellate purposes or post-conviction purposes in anyone's mind?
That's a perfect time to recognize Glenn right there. Glenn.
Thanks,
You got
Jay.
your hand up, Glenn. Yeah.
Right. So one thing I wanted to clarify before getting in that was, and I apologize because I wasn't at previous meetings, is this proposal to take care of the situation with current co-defendants, or is this proposal only about prior clients?
I think this is only about prior clients.
Okay, so this is not getting into the circumstance that was originally part of Bert's. Okay, I just want to make sure of that. I mean, for appellate purposes, we don't often get into facts outside of the record. So if a client came to us on appeal and said, hey, there was this possible conflict situation, we would certainly listen to the client, document it, and maybe ask some questions about it. But generally, in a direct appeal, that's not the kind of conflict that we could really get into unless it was in the record, the transcript, and litigated. But as to your question about post-conviction litigation, certainly anybody could file an MAR and say that, yeah, I wasn't adequately represented. They had, information that was from outside of, somebody else's file or whatever. So yeah, it absolutely could create problems for post-conviction.
Brian, you know what else could create a conflict? I know I was supposed to go. I'm going to go. You know what else is I didn't have representation, or I had representation from somebody who it appeared that they didn't actually want to take my case, right? Like the typical ineffective assistance of counsel versus, the PD's office would have been more than willing to take this, but for the fact that 10 years ago, when nobody was even there in the office anymore, that somebody could have represented them, but feels like they can't because of this rule. So, I mean, I definitely see your point, but I think that's also a bigger point that's even more tangible is the fact that somebody says, look, this judge appointed this person to me who doesn't even want to be my lawyer, and it showed.
Right. Well, and to your point, Judge, I know there have been scenarios where those types of claims have been brought up where appointed counsel had, 500 cases and they're just overwhelmed. They cannot provide competent representation. So I guess my question was kind of are we substituting one problem for another? And would it create more of a legitimate grounds, which I know is very kind of predictive. It's going to be subjective, all that kind of stuff. I just was wondering what everyone's thoughts were on that point.
And Brian, I will say this too, from a judicial standpoint, I talked to one of my mentors about this, who travels as a superior court judge, and was just like, and that individual was like, well, I would just appoint somebody to do it. And I'm like, yikes, because once again, you're going to appoint an attorney who charges maybe $100 something an hour to do a $65 case or a $75 case, right? Like, and the person sees that and feels that, then like, I think that's problematic. And we don't want that happening either, right? But, judges are strapped, people are strapped, that kind of thing. So that's the other issue that I think is when I'm going back to the appellate issue of they're saying, well, a judge appointed this person to my case and they didn't want to be here, I think is also challenging if the judge feels like they have no other options.
In my experience, for MAR purposes, post convictions, and I don't speak for every district attorney's office across the state, but I mean, the last thing I want to do is try a case under circumstances that I'm going to have to either try it again from the appellate perspective, or following an MAR, I'm going to have to deal with it on a post conviction or post appellate reality. But I also know it wouldn't be the first time that I've had to, and I use this phrase lightly, defend a defense attorney's work in defending a defendant. Um, and of course that means the file becomes open at that point in time. So all that work product we're talking about becomes, in some sense of the word, open to review by the court, by the prosecution, as well as the MAR counsel from that perspective. So, I think it we all recognize that reality. Um, and that's why I think the discretion of the public defender somehow in the notes or in the explanation somehow is going to be key, that it wasn't just that lawyer's decision to stay in the case or to get out of it, right? It was somebody else's objective or non-arbitrary decision-making process that they utilized, whatever process they utilized for that purpose, in order to protect that individual's constitutional rights. So I mean, and with that backdrop is really the benefit of having in the notes the ability for the uh, the public defender, as well as you probably need to include that the attorney general, because you've included the Department of Justice in this context, the ability to have the ultimate say whether there's a conflict. And I agree, I think somebody said if it's icky, well, we look, hey, if you pause for a moment in this discussion, that pause should tell you got to get out of it, right? And the last thing I want to do is force somebody in. But I know there are judges like that, and I know there are prosecutors like that out there. Lord knows I worked for one many, many years ago. Um, but I can't say that's the ideas today in the world of prosecution. I don't think are like that, generally speaking. So thank you.
Tom, to that point, also, it could be put on the record.
Right.
We believe that, Your Honor, typically there would be a conflict or whatever, but pursuant to Rule X, Y, and Z, we have done all appropriate screens, et cetera, and so forth, and do not feel like this is the conflict. And boom, that would preserve it for the record for appellate purposes. I mean,
That's correct.
yeah.
Hey, Fran, I see your hand too.
Hey, so a couple of things. First of all, Eddie, thank you for your comments an hour ago because you spoke my mind. I agreed with everything that you said. I've kind of forgotten now what it was because it was an hour ago. But I guess I'm a little confused because when we started out down this path, we were talking about representing current co-defendants, right? And then somewhere along the way, we've morphed into this other discussion about representing prior victims and, clients that the office represented years ago. And so I view those situations differently. And I think Glenn does too, based on conversations that we've had. So I guess I just want to kind of clarify, today, are we talking about representing prior clients, not current co-defendants?
Not
So
current co-defendants.
Well, and that's something I wanted to ask. And I appreciate you bringing that up, Fran, because as I look back at what we drafted, I think the drafted amendment could be read to actually cover current co-defendants. And that's something that we have, just as backdrop for the reason we included the North Carolina Department of Justice is that we had an opinion from '89 or something like that, where the Department of Justice has this statutory obligation to represent agencies, and some agencies have to go at each other. And so if they're on either side of the V, then that typically presented a conflict. But we have this opinion that says, the rules are rules of reason, and it's impractical to require the Department of Justice to basically choose an agency to represent. And so that opinion allows the Department of Justice, say, to represent the Department of Insurance and the Department of, I don't know, Bureau of Prisons or something like that, whatever it might be. And so I think this rule, maybe that's a question to this group. Should it allow two lawyers in the public defender's office to be able to be screened and say, we're not allowed to talk with each other? Our legal assistants, we have to tell our legal assistants, don't talk with each other. But we can have, defendant one represented by the public defender's office. Defendant two is also represented by the public defender's office because there is nobody else to refer the case out to. Is that like
And
what's
Brian, Deontay's
yeah, I'd love
fussing at me that I need to go to first appearances. But I'm gonna say I think that's a stretch. Like he's literally like go to first appearances. So but I do have to go. But Brian, honestly, I think that's a stretch. That is not what I'm advocating for. That co-defendant thing, I'm advocating for that what Bert talked about last time, which was he was not talking about co-defense. He was talking about past cases, older situations, nobody's there, the person's gone, all that kind of stuff. That's the one that I thought that we were talking about. That's the one I stand on. I'm not standing on representing co-defendants. I don't think Jacob is either. That's not what we're looking for. So I think that would shut it all down, and I'm not here for that. I just want to be clear on my position. And Deontay is still texting me. Okay. Bye guys. I'll see you at the next meeting. Sorry.
Thank you, Judge.
I mean, it helps to clarify that because I was getting confused because I feel very differently about those two situations.
I think we all do, friend.
And that's kind of what I was meaning. It seemed like we were nearly unanimous in our first meeting, and then we had to pivot a little bit, and we're trying to listen to Bert because he has such great thoughts, but it's different from the initial inquiry, in my opinion. Because I agree, I think it's very different from where we started.
So if I can clarify, it sounds like we're saying a disqualification based upon a former client conflict of interest. That is the one that we are comfortable with, but not a current client conflict of interest. Okay, we can add that language to specify that. So that's very helpful. Was that what you were going to say, Chief Harrow?
Yes, that's what I was going to say. There's a big difference between representing two current co-defendants. That, for me, that's an absolute no. Has all types of, again, scientific word, ickiness to it. But what you just described, yes, I'm all for the second scenario you described.
And I agree with Rodrina, like co-defendants, that's just no, we can't do that. But a former client, this would really, really help indigent defense.
And
Can
I
I
think
just
that's
reiterate too that question that you had, Brian, as it related to like the notes, the Odyssey notes, and Chief Baker Harrell speaking about how those attorney notes is the file and all of that. There's no way to screen that off. Like that file is the office's file, the office file, not that particular lawyer's file. So I think it just goes more to that point of that co-defendants that I just don't see how that even remotely could work in that circumstance.
And I find that interesting because when they started talking about Odyssey, that was one of the first things that we had public defenders and DA's offices talk about is you're going to have to figure out a way to put security around certain cases. And they were like, nope, can't do it. And I'm like, oh my gosh, I can just see these issues arising. Number one. Number two, my point about the South Carolina rule, I think if you read the South Carolina rule, you can actually contemplate a situation where you have co-defendants within a public defender's office being represented by different assistant public defenders within that office in the parameters of the South Carolina rule. That's why I was like, there's almost a presumption for representation except for this, as opposed to the cautionary aspect or the cautionary way in which our rule kind of seeks to make sure we cover those bases. And I think ultimately, since we're all on the bar council, ultimately to reduce the number of bar complaints against lawyers for this issue, irrespective of whether in the public defender's office or not. So.
And one thing that I want to maybe seek some confirmation on. I hear what you're saying, and I'm thinking another aspect is just public perception. When you have that co-defendant represented by the same office, there's a public perception thing. Looking at the former client issue, to looking at and speaking to our public defender representatives here, do you feel like there is a similar, a lesser or maybe no perception issue that you would run into if you are dealing with that situation where, hey, the person I need to cross-examine, the victim in this allegation, is our office's former client? Do you see similar perspective things?
I don't see it from a victim perspective. I see it from and I'm going to use some street vernacular here, is when I'm prosecuting a PWISD case and my snitch who is testifying against the defendant who is represented by the public defender office was previously represented by that public defender's office in their case that may have been 2 years before they began working off some other charges. Now obviously if they're working off charges that the public defender's offices had represented them on, that's different, right? But let's say their case is completely done and over with, but now they're testifying snitch, for the lack of a better phrase or word, and they were represented like 5 years ago or 2 years ago. Case is closed, over with, pled, whatever. But now you've got a defendant who is going to have to cross-examine that former client, so to speak. And I've had public defenders go both ways on this. I've had them like, no, we can't represent that person because they were under those circumstances. But I think this rule would, in some respects, allow that public defender to go forward, assuming they've done what they're supposed to do within the confines of the rule. Not saying they would, and I understand if they decide not to, completely. But I think it gives them that flexibility under limited circumstance, or obviously the passage of time, it would be important there.
I think that scenario that you described, to answer your question directly, I think it makes it less of a negative perception in the public. I think try to align with your wording, because as you make it plain, two co-defendants, everybody's going to see that as like out the gate immediately. The feeling is going to be, the gut reaction is going to be, there's no way that there's not a conflict because they're co-defendants currently, as opposed to somebody previously being represented and Chief Baker Harrell being able to say, you know what, yes, we did used to represent this person, but it was 10 years ago. Or maybe that's different than it was 2 years ago, and they're a frequent flyer, and we represented them on numerous cases, and we know them so well that it would just no way. Like, those are different scenarios that should be vetted, that should be weighed. And I think that in the perception of that would be appreciative. People would be appreciative of folks weighing it and then waiving it in that way. I think that's the typical kind of screening process that we know of, that offices do. They go through and they say, how much contact do we have? How much involvement was it? How much information do we know? All of that good stuff. I also want to point out, Brian, that with Odyssey, another thing about Odyssey, you have the attorney notes that Chief Baker Harrell has been speaking about. But then they have these notes in the actual public files that, depending on which county you're in, might have different things. So like, I just looked up here just now, where we used to have like clerk notes, attorney notes, certain types of notes. And then now my county has GAL notes, and it has like investigator note. Like, it's all these different categories that weren't on there originally, that depending on what skill set and skill level you have with Odyssey, you may not realize that you're putting some information in one section that is considered what you're thinking. New person may be thinking that it's confidential attorney notes when you're putting it in the public attorney note. You get what I'm saying? So I think that Odyssey thing is just one that we're going to continue to have to deal with and weigh and vet in all of these conversations that we have. And so that much more reason why we need to be able to give that authority. I think giving that authority to the chief public defender, and them knowing how all of it works and being the most knowledgeable one, hopefully, in their office as it relates to all things, and especially Odyssey, that will help cover all of that.
Chief
The
Harrell,
only thing I wanted to chime in that scenario that you just described, it still goes back to discretion, allowing the chiefs to look at it and determine, is this a case we should handle, or is this a case that we should assign to another attorney? There's a difference between dealing with a witness who we might have represented 2 years ago versus dealing with a witness we represented 10 years ago. 2 years might be too close in time, depending on the nature of the case. 10 years ago, I might be willing to say, hey, let's keep this in-house because it has been 10 years. And there's, lots of other cases or times in between. But that's when you have to rely on the discretion of the chief to look at the case, evaluate the situations on a case by case basis, and make that determination of, do we keep the case or do we assign it to someone else outside of our office?
Thank you. Listen, I want to be mindful of everybody else's time. I know we all have other things to do too. So I don't know if we're in a position to vote on this draft of the rule, or if we should just plan to have another subcommittee meeting and continue this good conversation we're having to make sure we get this shaped like we want to.
Jay, I'd recommend we redraft based on today's comments, particularly to emphasize the limited application to the former client scenario. And I think everyone would need to put their eyes on that before we go forward with that.
Okay.
And also limiting making it clear that it is just the chief public defender. Would that
Yes. Outlining that kind of funnel of authority and all of that stuff.
That sounds like a good plan to me. So everybody, without taking a formal vote, is everybody good with that? We'll just let Brian and Nicole take another shot at it, redraft it, and then we'll have another subcommittee meeting and follow up and discuss this further. And hopefully at that time, maybe we're ready to take a formal vote on it and move it forward to the full committee. Does that sound good?
Great. And can I just say thank you, everyone, for the thoughtful conversation. This was fantastic, and I feel like we sorted some things out, and this is, an improvement on what we are looking at, but really something that carries out the bar's mission of protecting the public, empowering the profession to do the right thing. So this was great. Thank you.
Also, I want a special thank you to Wadrina and Glenn for being here today. Really,
yes.
Very helpful to have you guys here. Thank you.
Yes.
Jacob,
and
Deontay,
Jacob, all of you. Thanks all our guests for being here. It's helped a lot. It is kind of amazing how far we've come, from where we first started with Bert's first inquiry. So, all right. Well, if that's the case, unless anybody has anything else, then we can adjourn this meeting, and then we'll reconvene another meeting at some point after y'all get some more work done, some more typing.
Sounds good. We'll be in touch.
Thank y'all. Y'all have a good one, Brian. See if you can throw in the word icky and give
if I could reduce
that
the
word
rules
all the time here in the office.
I'm telling you,
it is a scientific word. Icky is scientific.
I agree
I promise
with you, G.
everybody would know what that means.
I have often said the rules of professional conduct can basically be summarized as, if it feels icky, don't do it, and don't be a-hole. How about that? I don't know if we've stopped streaming yet, but I stand by that statement.
All right. Thanks, y'all. See you again soon. All right. Bye-bye.
I feel like a loading thing. Is this where we'll give you you can't do this message?
Mm-hmm.
Would you get this far?
The first time, yeah.
Just do requests.
Oh, is it because of the account you're in? Like the YouTube account? Do you know what I mean? Like, as opposed to being in
Like a personal account.
Right. Would that have anything to do with it?
Could be. Because when I'm streaming, I'm using our state bar account.
Yeah.
That might be why.
But this is supposed to be
But how's she streaming?
my State Bar account. It's not my personal.
Oh, okay.
And so now it's, I have to go through all this authentication.
And it's the same thing that happened this morning.
I didn't even take it this far, but that first,
Yeah.
right. We just stopped it then because I was like, I don't have time for this.
Yeah.
Maybe it was a one-time thing. It might be a new thing they did.
So even if I set it up on YouTube and I plug all that stuff into Zoom, you still have to go in and hit those buttons to say then configure to live stream?
Yeah.
It seems like stupid.
Or not configure,
So
but
it says-
Custom live stream seems dumb. It's like, well, what's the point of freaking whatever? But that, and I'm, because that's probably because that's your T, I'm assuming is that your
yeah, if you,
is that account.
Oh, that's my daughter.
there we go. That
That's
could,
probably what it is, Switch account,
yeah, if you go switch account.
but that's the only one that's there.
That's weird. But see, that's my personal. I
Right.
don't want to do that.
Yeah. Hmm.
I think that's gonna work. That's a Google sign in.
Yeah.
I'm gonna go downstairs and take a look at the YouTube setup. Maybe I'll add you. But
Okay.
yeah, I saw that T too. I'm like,
And I don't know how that happens because
Right.
on Zoom, it's me
It's you. Yeah.
right.
with my state bar email.
When I set things up on the YouTube account, it's like when I'm normally just like using Google or whatever, it's like under my personal account. But then when I go to YouTube and I have to set up YouTube, I have to pick like the North Carolina State Bar account.
Okay, and so that's
And so
not
I'm wondering, that's what I
that
was
doesn't
wondering.
appear to be set up.
Yeah, so that's what I was wondering. I was wondering if that might be the.
So I'll have to create an
How
account.
did you
But how
stream
have we done
it?
it before? Yeah.
How did you stream it?
This has never happened.
Yeah. It's not stopping until it started punching into that.
Let's stop. Let's stop this one. You can stop this one. Let's see if it pulls
Pull
up.
up on mine.
Or keep it running right now. Let's see if you can see it. Because it might automatically stream anyway, but it's showing you that it's not because of your daughter's name, but it's automatically streaming. So we'll just check to see if she can actually see it. And if she can see it, then we're good as far as your streaming. We just need to get you access to the YouTube account. Did you recently clear out your cookies or your cache or anything?
I never remember to do that. So it says sign in with my Google account.
Let me see something.
Why is it forcing me to do that?
No, let me just go grab my laptop. It'll be a lot easier than trying to manipulate all of it. Settings.
So I have my camera on
Mhm.
and my audio on.
There might be a little bit of a delay. So I see your camera on. Settings.
So I have my camera on and my audio on. Yeah.
So you're still streaming.
Okay, so even though, so I'll just ignore the error message.
Yeah, because you're not, yeah, so the error message is just because you were on you said that was your daughter's account.
Yeah, and I don't even know how that happened, which means that I went upstairs and she came downstairs and got on my